If you run business in Poland and some of your people work for you on a B2B contract or a civil law contract instead of an employment contract, then this video is for you. Because from this summer, the rules of game change. The Polish labor inspection is getting a powerful new tool. The power to turn such B2B contract or a civil law contract into an employment contract with a single administrative decision. And the tax authorities, they already have treated the classic "let's move our staff to B2B" plan as tax avoidance. I'll show you a real advance ruling issued by the head of Polish National Revenue Administration, where exactly that kind of plan was shut down. Hi, my name is Michał. I am a licensed Polish tax advisor and I provide accounting, cost calculation, tax compliance and tax advisory services for small and medium-sized businesses in Poland. Today we are connecting two things most people look at separately, but that are in reality two halves of the same story. The first half is the reform of the Polish state labor inspection, and the second half is an advance ruling, specifically a refusal to issue such advance ruling, where the head of the Polish National Revenue Administration looked at the company's plan to convert employees into B2B contractors and said, no, this is tax avoidance. By the end of this video, you will understand what is actually changing, what test decides whether your B2B contractor in reality should be treated as an employee, why a single labor inspection decision can turn into an income tax, VAT, social and health insurance bill reaching years into the past, and what are some examples of what already has been tried not to fall under the radar of audits performed by the National Labor Inspection, aiming at verification of B2B agreements. Let's start with the labor law side, because this is the big structural shift. Here is how it works today. In Poland, the definition of an employment contract lives in the labor code. It says that if someone performs work personally under your direction at the place and time that you designate in exchange for pay, then that's employment. It doesn't matter how such agreement is called. A contract labeled as a B2B agreement can still legally be employment agreement if that's how it looks like in practice. But here is the catch under the current rules. If the labor inspection believed that a B2B contract was really disguised employment, it couldn't just decide that on its own. It had to go to the labor court and ask the court to establish an employment relationship. That takes time, it's adversarial, and in practice it limited how often this happened. The reform flips that. Under the new law, the regional labor inspector can issue an administrative decision that establishes the existence of an employment contract directly. No lawsuit is required first. The typical path is the inspector issues an order to fix the violation, and if that's ignored, the inspector issues a formal decision reclassifying the relationship as employment. And that decision may carry weight across the board: labor law, tax, social and health, insurance. This decision can be appealed within 30 days to the labor court, and filing the appeal suspends enforcement until the court rules. But notice the shift. Now you are the one who has to go to the court in order to overturn this decision, instead of the inspector having to go to the court to make it. In plain terms, every civil law or B2B contract in Poland can now become the subject of an independent assessment by a labor inspector. On timing, this reform takes effect on the 8th of July 2026, which, as I record this, is just days away. And there's one more piece you need to know, namely a transition window. For 12 months from the day the law takes effect, there's a voluntary conversion period. An employer can voluntarily turn a civil law contract into a proper employment contract without being punished under labor law for the past. Now, this is the part people miss, that amnesty is about labor law penalties only. The tax, social and health insurance consequences of the past can still be a separate question. So it's a window of opportunity, but it may not be a free pass on everything. So what is the labor inspector actually looking at? The starting point is those mentioned constitutive features of an employment agreement. You do the work personally, you do it under subordination, that is, under someone's direction, and you do it at a place and time designated by the other party. Let me make that more concrete. In a genuine business-to-business relationship, the contractor genuinely decides whether and when to do the work. The contractor carries the economical risk. There are real consequences if he does not deliver. He can serve other clients. He can send a substitute. Compare that to someone who has to be personally available to one company during set hours, doing the same task they always did, with no real downside risk of their own. That person is, in substance, an employee, no matter what the contract says. And another important point, it's not enough to insert nice clauses into the document, into the agreement itself. The labor law inspection may look not only into such agreement, but also look at the actual conditions under which the work is performed, and not only at the wording on paper. So the practical takeaway from this part is not to build your defense on a single clever clause. Build it on a genuinely different reality. Now let's cross over to the tax side, because this is where it gets really instructive. And this is the advanced ruling I promised you. First, some context on what an advanced ruling is. In Poland, there is a general tax anti-avoidance rule. According to this rule, a transaction shall not result in a tax benefit if that tax benefit, being contrary in the given circumstances to the object or purpose of the Tax Act or its provision, was the main or one of the main goals of carrying it out, and the manner of acting was artificial. Additionally, if you are planning an arrangement and you would like to be certain that the tax office won't later attack it as illegal tax avoidance falling under this mentioned general tax anti-avoidance rule, you can apply to the head of the Polish National Revenue Administration for a so-called advanced ruling. If the tax authorities grant such advanced ruling, you are protected. If they refuse to issue such advanced ruling, that's a very loud signal that means that they think your plan is illegal tax avoidance falling under this general anti-avoidance clause. In this case that I am about to describe to you, the issuance of such advanced ruling was refused by the Polish tax authorities. So let's look at what the company that applied for the issuance of such binding ruling wanted to do and why it got shut down. The plan had two moves. Move 1, a joint stock company would set up a new subsidy, a limited liability company. Move 2, it would take some of its current employees and change their employment contracts into B2B contracts with this newly established subsidy. And why do it from tax point of view? As employees, those people were taxed on the scale 12% and 32% on income above 120,000 zloty in a year. As self-employed contractors, they could switch to the 19% flat tax or the lump sum taxation, where the rate, depending on the service, runs from 2 to 17% of revenue. On top of that, the company would stop being a withholding agent. It would no longer have to collect tax on their pay, lower the tax for the workers, and less administration and exposure for the company. On paper, very attractive. So why did the head of the Polish National Revenue Administration said no? He ran the plan through the 4-part anti-avoidance test, and it failed all 4. In the first step, following the provisions of the General Tax Anti-Avoidance Rule, the tax authorities asked themselves a question whether there even is a tax benefit. And the answer was, yes, there is a tax benefit. The workers' tax bill drops. Clear tax benefit. The second question that the tax authorities analyzed is whether that tax benefit is contrary to the purposes of the law. And their answer to this question was also yes. They stated that the Polish tax law deliberately separates income from employment from income from business activity and taxes them differently. And the tax law contains specific provisions designed to stop what is called as a fictitious self-employment. Let me define this because this is the heart of the whole thing. Fictitious self-employment is when you register a business, but in reality you provide services only for one entity, usually your former employer, doing essentially the same job under their direction and at their time and place. Only the legal label changed and the substance didn't. The law is built to prevent exactly that, so the plan designed to achieve it runs against the law's purpose. The third question that was analyzed by the Polish tax authorities was whether achieving this tax benefit was the main or one of the main goals of the whole plan. And here the answer to this question was also yes. And here's the detail I love. The company itself, in its own application, described the whole plan, the whole operation, as a change of the form of employment. Think about that phrase. They didn't say, we're launching genuine independent businesses. They said they were changing the form, while the people kept doing the same work, in the same place, using the same infrastructure. The head of the Polish National Revenue Administration accepted that some reasons presented by the company for creating a subsidiary were legitimate. Diversification, isolating risk, that kind of thing. But the reasons given for converting the people to B2B were found not credible and achievable by far simpler means. And the fourth and last question analyzed by the Polish tax authorities was whether the whole plan, the whole structure was artificial. And the answer to that question by the Polish tax authorities was also yes, and on 2 levels. Economically artificial because there was no economical substance. The same people doing the same tasks in the same place, with the subsidiary actually renting back the parent company's office and equipment. And legally artificial because if the company genuinely wanted to carve out a business line into a subsidiary, there's a clean, ordinary legal route to do it. A division by separation defined under company's commercial code, which would have carried the staff over as a transfer of a workplace under labor law. The company applying for the advance ruling didn't wanted to use this clean route. It used a roundabout, one whose main effect was the tax saving. So consequently, all the 4 boxes were ticked by the Polish tax authorities. And from their point of view, the Polish tax anti-avoidance rule would apply in such case. And therefore the issuance of the advance ruling was refused. And here is why it matters to you, even if you will never build a subsidiary. The lesson isn't don't set up companies. The lesson is that wrapping disguised employment inside a sophisticated corporate structure does not make it safe. Polish tax authorities may look straight through the structure to the economic reality, the same way the labor inspector now will. Another example for what people are discussing and also trying to do is to, instead of an employment agreement, let the employee set up a Polish limited liability company that will carry out the services. However, according to some opinions of labor lawyers that I am aware of, also this solution may not offer 100% security, as according to their standpoint, an employment agreement can be identified and established between the entity receiving the services and the natural person actually performing the work, the services, at the site of the limited liability company being the official legal service provider. A labor inspection decision reclassifying a B2B agreement into an employment agreement may not necessarily only stay within the labor law. It may detonate on the tax side, as the databases between National Labor Inspection, Tax Administration, as well as Social and Health Security Administration are connected. Start with a subtle but crucial point. Let's assume that the labor inspector's decision works prospectively, going forward from the date it was issued and not backwards. So you might think that the past is safe. That decision may become a trigger. Once there is an official finding that this really was employment, the tax office and the social and health security institution can open their own checks into earlier periods that aren't yet time barred. And in Poland, that generally, very generally, means up to 5 years back. The labor decision doesn't reach into the past, but it hands the tax office a reason to. And the bills stack up. From the moment of reclassification, your company becomes tax, social and health security withholding agent. You now have to calculate, collect and pay the tax, social and health security contributions to the tax authorities and social and health security institution. What used to be contractor's invoice gets treated as a wage, which can mean grossing it up and finding the tax out of your own pocket. Then there's also VAT. Think it through. Your former contractor was issuing you VAT invoices and you were deducting this VAT as your input VAT. If this relationship in reality was employment, those invoices should never have carried VAT and should never been even issued. They potentially might be treated as so-called empty invoices with consequences for the entity which issued them. And at the side of the entity receiving these invoices and deducting input VAT indicated on them, this input VAT deduction may also be challenged by the Polish tax authorities. It can be a mess at the side of the invoice issuer as well as at the side of the entity receiving this invoice. One last thing to internalize. These institutions no longer work as silos. There's now automatic data sharing between labor inspection, the tax administration and the social and health security institution. A system built precisely to flag illegal B2B and civil law agreements. So a labor inspector's decision doesn't sit quietly in a file. It flows straight to the people who collect tax and social and health security contributions. Additionally, please also note that within the reform of the labor inspection, you might not only receive a prospective decision, namely a decision which is effective from the day it was issued into the future, but also within the reform of the labor inspection, the labor inspector receives a right to file the whole case to the labor court in case he comes to the conclusion that the given B2B agreement, a civil law agreement, should be treated as an employment agreement retroactively. And in such case, the labor court will decide whether this civil law agreement, this B2B agreement, in fact should be treated as an employment agreement retroactively in the past. And in case of such decision of the labor court, this relationship will be treated as an employment agreement from the given moment in the past. Now hopefully you can see why I connected these two stories. They are like pincers closing from two directions on the same thing, namely the disguised employment. From the labor law side, the labor inspection can now reclassify a contract as employment by its own decision after looking at the real conditions of work and not at the paperwork. And of course, such decision made by the labor inspector independently will always be only prospective. Namely, a given agreement will be treated as an employment agreement from the date such decision was made. And from the tax side, I have shown you an example in this video in which tax authorities have already convert our stuff to B2B to save tax as tax avoidance. Put bluntly, if your B2B or civil law agreement in reality is employment in disguise, you now face risks on both fronts at once. First, audit your contracts now during the 12-month conversion window. Identify any relationship that looks like employment in substance. For example, one client, fixed hours, working under direction, same desk, no real business risk, and decide deliberately how to handle it. Secondly, if a relationship genuinely should be employment, the conversion window is your chance to fix it on the labor law side without penalties for the past. Use it consciously. Thirdly, where the self-employment is genuine, and plenty of it may be, make sure the reality matches the form. Real autonomy over how and where the work is done, the freedom to serve other clients, the right to send a substitute, the real economic risk at the site of the contractor, proper invoices and acceptance documents. There also is the option to ask the labor law authorities for an official interpretation, an official ruling, before you finalize a given contract, a given business relationship. And the golden rule underneath of all of it: don't rely only on labels and clever clauses. Build and practice a real relationship that genuinely is what you say it is. Okay, I hope it helps. That is all for today. Thank you very much for watching. Take care, and I will see you in the next one. Bye!